Hello, I'm Rex Crandell, CPA and attorney in Walnut Creek, California. And we're here today to talk about postmortem estate and trust administration, what to do with an estate plan after somebody dies. That's the topic. We're going to be going through it in detail. We have a lot of slides, examples, and information um, for you so that you can learn how to take care of those responsibilities or at least know what they are. Let's see here. Okay, what to do as a survivor after the death of a loved one. The first thing you do is you read and follow the trust document. The trust instrument is the marching orders if you're used to military, or it's the instructions uh, on what the trustee is supposed to do. And you augment that with what are the requirements of California probate code. But the main thing you're doing is following the trust. Okay. You need to determine what the decedent's wishes were regarding burial, cremation. Those are generally in a document called Advanced Healthcare Directive. But as successor trustee or executor, you need to be responsible for that. Um, a lot of people will have ashes scattered at sea or in the mountains, things of that nature, or put in an urn until the second spouse dies. Quite a variety of activities. We had one that had their ashes scattered in Nevada desert by Mount Rose, and then the second spouse to die, they wanted to be in the same place. Just an example. Obtain copies of the death certificate. That usually will come from the funeral home, and it may take 2 or 3 weeks to get that death certificate. They're very ornate documents. I would order usually about 10, unless the person had a lot of assets. Then I would do a lot more in terms of what documents. Um, Let me just go up here. It's intro. Okay, so I'll find out whether the decedent had a will and what other estate planning documents. Most estate administration, if they have a trust, is not governed by the will. Um, the only thing that's usually governed by the will, instead of um, you know directing everything to go do what the trust says, is a nomination of a guardian for a minor child is only in the will, and then the judge actually appoints the person that they want, I think most qualified. Apply for a federal ID number using SS4 form, or we also do them online while the clients wait. Um, Figure out the domicile where the person lived. Um, okay. And for estate administration, it's usually the office for of the trustee is where the trustee lives or has a professional office. Um, Sometimes we'll administer trust based on when real property is located, and that would be the county where the property is. Um, and the administration might include multiple jurisdictions. For example, if they have a couple rental properties, um, They live in San Francisco, they have a rental property in Walnut Creek, and they have another uh, rental property in Baton Rouge and another one in Las Vegas. So you have multiple jurisdictions, and hopefully the property was titled in the name of the trust, so you do not have multiple probates to administer. Determine what types of professional advisors you might need. Attorney is a possible, certified public accountant for tax or enrolled agent, or someone licensed under the CTEC rules, California Tax Preparer Education Council. If the decedent has no surviving spouse, then what you would probably do is change the locks on the house so that things don't disappear. If family members who are not the executor or trustee have access to the house, seal it off so that the personal property doesn't disappear. Look around for possessions of uh, checkbooks, credit cards. Uh, in most trusts, there'll be a Schedule A at the end of the trust. That's an idea of where some of the assets might be, but you might also end up looking in the mail that comes in. Um, you might also put a forwarding address so that the mail goes to the trustee rather than to the decedent's house. Um, you might notify the homeowner's insurance company and auto insurance of the death to make sure that the coverage is adequate because you're responsible for protecting the assets that are in the trust. So if you don't have enough, like say fire insurance on a house, you could be held personally liable if later there was a fire and you did not have the proper insurance. So oftentimes you cancel certain pending contracts uh, or go through with them. Say if you're in the middle of a real estate transactions, um, you might end up having to rewrite a real estate purchase contract so it shows the trust as trustee or executor. Um, you might try to find a safe deposit box and inventory the contents. I recommend here that you bring another person and videotape the access to the safe deposit box so that another beneficiary doesn't say that things were missing out of the box. Um, Determine the heirs at law who would inherit if the decedent did not leave a will or trust. There's a chart that we use. It's called the table of consanguinity. Sangre is Spanish for blood, and it's very close to the Latin word. The bloodlines, and that determines who would be potential heirs. Um, Heirs, the definition is people who might inherit or could inherit, and that doesn't mean anything has been allocated to them. The term beneficiaries are those who are named in the will or the trust, and so then they have a beneficial interest. Decide whether there's going to be a probate of the will, see if it's necessary. When assets are titled in the name of the trust, you don't have to be concerned about a will. But when assets are left out of the trust and they were in the decedent's name alone, it creates problems if the value of all that property, real or personal, exceeds 184,500 for the decedent. And if so, then you're going to be burdened with the procedures related to probate. You need to make a determination whether a supplemental probate may be necessary in another state. Um, for example, if you had a trust administration in California and another property in New Hampshire that was held in the individual's name, then you'd have a probate in New Hampshire. Um, Decide whether a temporary administration of assets must be done immediately. For example, um, you have a business, you need to get somebody in to manage it right away, immediately, or like say a dairy farm, you have to make sure that all the cattle have proper food and care, and find out if there's anything that needs to be handled right away. And either you do it yourself as administrator trustee, or you hire somebody out of the funds. Oftentimes, trustees and executors will advance their own funds, keep receipts, and later get reimbursed for the loans that they're making to help the trust administration. Um, so when you're working with clients, remind the client to bring the important documents to the meeting, and that would be the trust, the both husband and wife wills, um, the durable power of attorney for asset management is less relevant because it's void on death, so nothing's going to be done with that document. And the advanced healthcare directive, not so much for the healthcare aspects, but for the what the decedent had in mind for burial and um, working with the remains. Um, the original will needs to be filed with the Superior Court within 30 days from the date of death under this probate code section 8200A1. What we do is recommend bringing an extra copy so that the court clerk can stamp that you filed it within the time frame. On the downside, in most attorney meetings, we ask, has anybody gotten a penalty for not following that requirement for the 30 days? And no one's ever heard of any law enforcement in that area, so I wouldn't worry about it. A lot of places in the probate code, there's no requirement to do anything for trusts or estates for 40 days after the date of death. And that's kind of the rule that we use in our office. Um, Nothing's an emergency like that. The family has to adjust to all the changes within the family, the emotional changes. And when we get a call for someone who passed away last week or a couple of weeks ago, we try to slow down the process and suggest maybe they want to come in next month, so that all the other adjustments for emotions, property management, protecting assets can be taken care of. Okay, notification and marshaling of assets. So you need to notify third parties that if they're, for example, if the tenants for rental property are now going to have to send their checks to a different place, you need to notify them. The term marshaling of assets comes in, um, and that generally has to do with the word means management, basically. Um, you need to start thinking as process for inventory and appraisal of assets in the estate, both real and personal property, and think ahead a little bit about what the trust says about allocating assets or distribution. Checklist, have a complete, thorough client meeting checklist. We have one that's several pages long and it's extremely detailed. We'll share it with you later. That was put together by the continuing education of the bar. And it's helpful because you don't always remember what tasks need to be um, taken care of. And when you do this kind of work, you don't want to become calloused and realize that the big emotional impact of this death has on the families and the people that you're working with. Um, you never want to lose sight of that fact. Um, Most of the checklists that we use, we do not share them with clients. It's things that we use and we don't bother defining things so the technical terms are good enough for us that we know what they are. Um, you might think about at that point starting to get with the trustee and executor who are all the beneficiaries, where's their mailing address, telephone, and email address for all the people that you're going to need to be corresponding with. And when you're the trustee, you need to deal with all the beneficiaries, and the same with an executor of a will. However, from our office as a law firm, we work with the trustee. We do not work with the beneficiaries. We do not have attorney-client privilege, and it's inappropriate at times for our office representing the trustee to communicate directly with the beneficiaries, other than preparing notices, um, required legal notices. Okay, application for a federal ID number. There, when someone dies, their social security number is frozen. When the bank finds out somebody dies, they'll close the bank accounts until you get a new ID number for the estate. And for a trust, a revocable trust, the ID number for tax purposes is the trust settlor or trust creator's social security number. But on death, the trust becomes irrevocable normally. And then the trust itself needs to get a federal ID number to file taxes and to work with banks and open accounts and that type of thing. Um, what happens on the federal ID number, we go through all the steps to get the new ID number, and then we get a letter from the IRS. It's all part of when we're doing it online, getting the ID numbers. We get the IRS response letter immediately, and then we print them out for clients, and then they can bring them to the bank because it shows the federal ID number. Um, in getting federal ID numbers, there's some confusion, and it's just terminology, and that is when someone's a successor trustee on a trust, then obviously they're a trustee. But when somebody owns assets in their own name, like they have the house in their own name, and it's not in a trust, then the term is called an estate because there's no trust. In the estate, the assets in that estate need a federal ID number if it's going to have income over $600 for any 1 year. And that estate ID number we used for banks and the probate. But there are situations where the estate's going to have over $600 of income this year, so it needs to file a fiduciary income tax return. But the trust also has over 600 of income for the year. And when that happens, you have two different ID numbers, and you need to file two tax returns unless you make what's called a 645 election, which allows the income from both ID numbers and both entities to be reported on one tax return. And it avoids the work of having to do one tax return for the decedent's estate and a separate tax return for the irrevocable trust. Um, okay. After you start doing trust administration, the first thing that we do is read the trust for content, how the distribution works, what are the provisions? Are there ongoing trusts that are going to last for several years? Does one trust create two or three trusts? Uh, it's reasonably common to find one trust that ends up being split into two parts, like an AB trust for the assets that are above ground and for the survivor, and the trust is amendable and changeable. And then having a B trust for the decedent who's below ground and different beneficiaries. And the assets have to be transferred to that B trust. Okay, so as a trustee, you should be aware of your fiduciary duties because you're acting kind of like a bank. Um, and there's this form DE 147 that has some of the uh, duties and liabilities of a personal representative. It's required for probate. It's optional for trust, but it does give some idea to the trustee or executor what their responsibilities are, such as you cannot commingle assets. Um, you have to treat the investment accounts as low risk. You have to move assets into income producing unless the trust says otherwise. Um, in that form that I'm talking about here, it's Judicial Council Form DE 147, and that's available online. Judicial Council is they're like the board of directors and they're immediately below the California Supreme Court. And so they make a lot of decisions and create approved forms for court use. And this particular form, as I mentioned, is required in probate, but optional for trust. Um, if you are doing a probate, you'll probably end up getting a fidelity bond that protects the beneficiaries from the administrators taking money out of the estate and not paying it back. This is an example of the DE 147. The executor administrator needs to put money in prudent investments, keep assets separate from his assets or her assets, and no commingling, put things in interest-bearing accounts, um, locate the property, find out where it is. Um, you can also hire private investigating companies to help locate assets. Sometimes we'll look on the California State Controller's Office and find assets that have escheated to the state of California because nobody touched the funds for over 4 years. One case, we've had a client and they had several $100,000 in money that had gone to the state controller's office that is cheated to the state. Um, You need to file a change of ownership report with the county assessor's office. Um, Give notice to creditors of the decedent's death. Um, Insurance, check to see if it's adequate and inform the insurance company. Um, you need to keep track of every penny in the estate and how the money was earned or spent, how it benefited the estate. Um, and then for probate, you have court review. And if necessary, hire an attorney to help with the administrative duties. Most all executors and administrators that we've ever worked with have never done this kind of work before. So they're not trained for it at all. And we provide the education and the guidance for them to get through the process, and we do what they cannot do, and anything that the successor trustee can do, they're willing to do that, that's fine. Um, There's a required notice when a trust becomes irrevocable on death, non-changeable. And that is what we call in the office a 16061.7 notice. And it must be sent within 60 days of death. Um, The trustee must provide terms of an irrevocable trust if it's requested. Um, some attorneys send the terms of the trust with the notice, although it's not required. We always do. So the form says basically that I'm the trustee, I'm in charge, here's my name, phone number, email address. And you contact me for any questions about the trust. And that either they have a right to get a copy of the full trust or um, they can get a summary. We always send it. It's a good idea to send these notices to all heirs by certified mail so you can prove that you met your disclosure requirement. This is an example of a 16061.7 notice, and just again, the purpose of this is to give the beneficiaries um, notice of the irrevocability of the trust and that they have a right to know this information, the trustee's address, contact info. Um, and that it also limits their rights. If they get a copy of the trust with a notice, they can sue within 60 days. Before that, they lose rights, or if no trust is given, they must bring an action. What kind of action? Maybe that they don't agree that the trustee should be the one in charge of it, or other issues related to the trust drafting or the trust execution. Inventory and appraisal. We suggest you check the title for all assets that have a title, such as real estate, investment accounts, stockbroker accounts, bank accounts, life insurance, retirement accounts. Um, See who the owner is and um, whether there's going to be a probate because too many things were left out of the putting in the name of the trust. Um, for real property, you always end up needing to get a real estate appraisal so you can determine what the value of the property is for the beneficiaries, and that appraisal is always done on the date of death. It's also used for income tax. Somebody has a big capital gain if they were to sell their house while they're alive. When they die and transfer it to their heirs, they get what's called a stepped up basis, which means that the capital gains is forgiven, and then the tax basis for gain or loss on the later sale of the property um, is reduced a lot, but you have to have an appraisal to claim that benefit of reduced capital gains in the future. If the decedent had a stock account, investment accounts, you need to work with the brokerage firms to get the value of all of these securities um, as of the date of death. You contact the brokerage house. Generally, they'll have to get a new account number because the trust has become irrevocable. But make sure that the stockbroker starts working on getting you that paper showing um, that the decedent's assets were valued what they were at the date of death, not what they were originally paid for. Um, Later, for gain or loss, the stock brokerage firm at the end of the year can properly tell you what the capital gain is for your tax return. If the brokerage house does not know the person died, then they're not going to step up the basis, and they will um, end up showing too much capital gain. Um, Generally, when there's real property and the person dies and the house is sold within a year of the death, most commonly there is no gain on the sale of the property because of all the sales expense, broker commissions, title fees, lender's fees, that type of thing. Another form to be aware of is under probate code section 13100. And what that does is it tells a third party, let's say there's a bank and there's let's say a 500,000 in a bank account in the decedent's name. Well, you can't use a 13100 if it's that big. But if the bank account was less than 184,500, then you can um, uh, you can notify the bank that that you're the administrator of the trust or the estate, and that you have a right to have that asset turned over to you. And if not, and if you have to get legal fees involved, that if the bank doesn't comply with the request, that the bank would be liable for the attorney's fees to obtain title for the estate. Sometimes we'll run across a situation where someone had property in their trust, then they refinanced their house, and at the end of getting the new loan, they forget to put the house back into the trust. And they die when it's outside the trust. And normally that would cause a full probate. However, if the asset was indicated in the trust as being a trust asset, the courts have a case called the Hegstead petition, which tells the court that, Your Honor, this property was in the trust. It's labeled as intended to be in the trust. The owner forgot to put the title back into the name of the trust. So we're requesting a court order to put the name of the property in the trust, and thereby avoiding the cost and delays of having a complete probate situation. Uh, this is an example of a 13100 form. Again, what in the heck is this for? It allows the administrator to collect property um, where there's no trust and the amount of the property is less than 184,500. And so the institution should turn the money over to the administrator. When we talked about the value for tax purposes of a property goes up, like a house that cost 200,000 to buy 30 years ago and is worth $1 million today, when the person dies, the computation for gain or loss starts at 1 million now, and you need to come up with that dollar amount. Um, the dollar amount needs to be determined by an appraisal. Um, we generally use a licensed professional appraiser to issue a report. It is an expense for the administration of the estate. Some people will take a little more risky route and use Zillow or Redfin or Realtor.com and come up with a value of the property as of the date of death on their own. Sometimes that's appropriate. Just depends on the circumstances. Then if you have this property, now it's worth 1 million, and then the trust says to distribute the house to daughter, then the daughter needs to know what the cost basis for her for tax purposes is. So this form 8971 is required to be given to the beneficiary when they get a distribution of real estate or some property that's not cash. And the term, if we distribute property out of a trust to a beneficiary, that's called an in-kind. That's the letters IN and then dash kind. In-kind distribution is given an asset that was not sold by the estate and given directly to the beneficiary. And in that circumstance, for could be stocks. We do several on the stocks. They just don't want to sell them. They keep the portfolio the way it was before death. Or it could be real estate, anything of value. And if you take the property and sell it in the trust or estate administration, this form's not required because the distribution is cash, not property. Trust certifications, banks frequently ask for them. Basically, it's a boiled down trust that gives some of the terms of the trust, who created it, when, some details about the trust. But some people are concerned that they don't want the world to know what is in the trust or who the beneficiaries are. So you might have to file a certificate of trust with a bank or sometimes with the public county recorder. And I don't have a problem giving a banker the entire trust rather than just a summary of it. But a lot of people are really concerned about that. So if you have accounts, when one spouse dies, the other co-trustee can simply keep monitoring or managing those accounts. And it's not a problem. It does not require, you have to remove the the decedent's taxpayer identification number from the account. So I would always bring a copy of the trust or a certificate of trust when you're dealing with financial institutions so that they're not going to work with you unless they can see in the instrument that you're the right person for this administration based on what the instrument said. Okay. This is an example of a certification of trust. And this I mentioned is basically a summary or a synopsis. And this form gives you kind of a format. It says the trust was created, name of the trust, when it was created, who were the settlers, who's the acting trustee, what powers do they have, if now it's revocable or irrevocable, and if there's multiple assets in the trust. This is a guideline. We frequently just write them up freehand with the necessary details. Okay, the estate tax return. This is rare these days. This is kind of a misnomer because it's a state and inheritance tax return. Form 706, it's when you say it just the state tax return, you might be referring to the income tax return, and this is entirely different. Now the level of assets needs to be above 15 million before you have to file an inheritance, estate or inheritance tax return. That's quite a lot. And if there's a husband and wife die around the same time, then that's 30 million, which means you do not have to file this tax return unless the value of the decedent's share of the assets exceeds 15 million for 2025. This estate and inheritance tax return is due 9 months from the date of death, to be filed with the IRS. If you don't have the papers together, you can file an extension of time to file for 6 months so that you can file later. But if there's estate tax due, it needs to be paid in by that 9 months from the date of death. These returns are quite rare right now because the average person doesn't have that much money. So there's a lot in the law and estate and trust seminars, lengthy hours-long explanation of this tax return and how the tax works and all the interactions. And less than 1% of the people in the United States have it. So if you're looking for things to learn and study a lot that are complex, this is probably not it because there's so few of them. We get them from time to time. I mean, 20 years ago, we used to get to do these tax returns all the time. But now at 15 million before the tax return is even implicated, they're not that common. Having said that, if you have an estate, let's say worth 20 million, and it's husband and wife, and one of the spouses dies, what you can do is voluntarily file an estate or inheritance tax return on Form 706 so that you can determine that exclusion from tax is 15 million. And if both the spouses die, you can take that first 15 million and have it allocated so that it's not taxed. But when the second spouse dies, assuming you have an AB type trust. And the other reason for filing these returns when you don't need to is the unused part of this exclusion. Say if it was 5 million and you only had 10 million that needed to be reported, that 5 million that you did not use on the Form 706 can be, they call portability, moved over to the surviving spouse and increases their surviving spouse exclusion from 15 million in this example up to 20 million. So it's just applies in certain circumstances. This is an example of page 1 of the RS Form 706 estate and trust, estate inheritance tax return. This part of it's pretty straightforward. The name, decedent's name, ID numbers, date of death. And then we get into how much the listing of the assets. Um, and there's work schedules on page 3 where you list the details of the total assets in the estate, and the liabilities are subtracted, deductions. And when the amount on line 8, in this case, exceeds 15 million, then based on the total is on line 8, and then on line 9, we start getting the exclusion. You can see how much of the estate is subject to the estate inheritance tax return. Excuse me. And that must be paid in by 9 months from the date of death, even if you have an extension of time to file. Excuse me. So I'm not going to spend too much time on it because it's somewhat rare. It does happen. When you're doing estate and trust administration, you also have to do accounting to the beneficiary. So you're both in a probate and an irrevocable trust, you're supposed to accumulate the income and expenses and give the beneficiaries reports on what the income and administrative expenses were. In a probate, you have no choice. You must do a fiduciary accounting every year the probate is opened, and the judge can approve your work. For trust, um, there is a statute that says you're supposed to do an accounting. It's kind of optional. And if the beneficiaries don't want it, then you don't necessarily need to prepare it. However, if a beneficiary requests of a trustee in writing that they want an accounting, the trustee must comply and give that accounting within, I believe it's 90 days to the beneficiary, or the beneficiary can go to the court and request that the judge remove the trustee for not meeting its requirements. They call it breach of fiduciary duty. Um, We have an example of an accounting in the material here. Um, This is it's a form called GC 400 from the Judicial Council of the state of California. And this form is required for both probates and for trusts. Um, we list all the assets on the beginning asset list that we had appraised and then the cash. Then during the accounting period, let's say for 1 year, all the income that came in and regular income, capital gains, gains on sale of property. And then you also have to show separately the disbursements for administrative expense, losses on capital transactions or loss or damage assets in the trust. So this form is required for both trusts and probate estates. This is an example of the same form, but only on a spreadsheet. Um, in our example here, we show expenses. In this case, we start out with income called receipts, and we show them all in chronological. Wait a minute. This is the um, cash on hand at the beginning of the period. So we call that the beginning inventory and appraisal. And if there's real property, it would be listed here, appraised value, jewelry. Then for the income during the year, there are government forms, but you can also do it on a spreadsheet. You can show every receipt that came in chronological order. And then you can show alternatively for the beneficiaries the income that came in by categories, say stock dividends or IRA interest, within the separate accounts. And showing it both ways helps the reader understand what happened during the year. Then if you sold stocks or had other capital gains or losses, you would show those on the gains during the period. So we're tracking all the income, transaction by transaction. You have to report the income, um, not only the regular income, but the capital gains. Then for the expenses during the period, you have, in this example, there are other government forms you could use, but we're showing all the amounts paid out chronologically first. And then we show the expenses by categories. And you have to include the pennies. You cannot round off the pennies like you do for property income tax returns. This is a schedule of loss on sales of assets. And then you have a schedule for distributions to beneficiaries. Um, and when you give money to the beneficiaries, you always get a receipt so that you can prove that the amount that they received is, they don't want to ask for it again. Uh, And then you list all the property on hand at the end of the accounting period. Okay. So, uh, um, we're out of the accounting, now. And let me go to some forms, tax forms. Um, The 1040 is due for the decedent up to their date of death. The 1041 fiduciary income tax return is prepared for income received after death. The Form 706 is estate and inheritance tax return, Form 706. If a person gave more than 18,000 during the year or in prior years, then they should have filed a Form 709, and that reduces that 15,000 that we talked about um, for estate and inheritance tax returns. When you're doing tax returns, a 1310 form, if there's going to be a refund on a fiduciary IRS Form 1041, the IRS wants to know the identity of the administrator. The SS4 form is used to get a federal ID number for the estate or trust. You want to get all of the 1099s for the decedent and make sure that they go on the tax return. Then things are a little bit different on the death of the second spouse, because then we're no longer holding assets and more things are going to be distributed. Need to go through the checklist of what needs to be done. Um, um, when there's two trustees, for example, or any trustee on the public record on a deed, we prepare and file an affidavit of death of trustee so the successor trustee can take over. And we have to file it with an original death certificate. And then we also file a change of ownership statement, death of real property owner, and that goes to the county assessor, not to the recorder, so that the county assessor can determine if property tax needs to be reassessed. If there's going to be an exemption from property taxes going up to market value, and a parent lived in the house and a child's going to live in the house, we prepare this form to keep the property tax lower, because transfer from parent to child, there's times when the property tax might go up $10,000-15,000 a year because it's based on market value. And with this form, you can keep the property tax much lower. You can also transfer from grandparent to grandchild if the middle generation are all dead. Two people owning property not married, they can exclude property tax reassessment. Same can domestic partners. Need to fix the deed so that eventually you're going to make a deed to distribute the property or sell it. You also have to file this form preliminary change of ownership report with every deed, or you're going to get penalized. So if any of the property is held in the name of an LLC, then you would have a Form 568 due as part of the administration. And there's some other legal entity agreements. Like I said, you get a receipt and agreement with the beneficiaries that they've looked at the accounting and they're agreeing that you did the proper accounting and that release a liability for the trustee. These are questions, you got to make sure you treat all beneficiaries equally. Generally on death, a revocable trust is no longer revocable, it becomes irrevocable, but that really depends on the term of the writing in the trust. Property tax is a huge area in estate and trust administration because of the high cost of real property tax after the death of a property owner. So that's the material I wanted to cover today. Thank you for attending the postmortem estate and trust administration, or what to do with property after a person dies and you're in charge of administering that estate or trust.